This is Mike Franklin, the property tax guy, and as promised, I'm going to review section 131.1C that William Ramseier, the state hearing officer, indicated was his source to deny my right to video record an assessment hearing. So I'm gonna review that section of the law and see if you agree with his assessment of the matter. Before I get into that, anyone who has concerns about your assessment or how your assessor conducts business, feel free to contact me, and I'd be happy to look into it. I'd be happy to audit your assessor if for irregularities, or to see if they're doing a great job. Feel free to call me on that. Or if you want me to take a look at your assessment, see if you may have a case to get a reduction, I'd be happy to do that as well. So let's get into the review of 131.1C of the rules of the Chief Administrative Judge. Mr. Ramseier, in his decision on the assessment matter, ruled or indicated the following. Petitioner and her representative, Michael R. Franklin, that would be me, appeared in this matter. Mr. Franklin requested the proceeding to be video recorded for his use as a journalist. This request was denied pursuant to section 131.1C of the rules of the Chief Administrator, period. Upon his request to reconsider, Mr. Franklin was advised that he may audio record the proceeding. Mr. Franklin objected to the denial to video record the proceeding, but denial to video record, to video record the proceeding, but did audio record the proceeding. And that is true. But his ruling is this request was denied pursuant to section 131.1C of the rules of the Chief Administrator. He provided no substantiation of how this case is relevant to 131.1C. And during the hearing, he was asked numerous times to explain why we cannot record why we cannot video record this hearing. It is a highly public matter, and there is no reason why it cannot be recorded. There's no victims to protect. The assessor has no expectation of privacy. The hearing officer has no expectation of privacy, and myself and my clients, want it to be recorded. So, he provided no logical explanation, that it might interfere with somebody else's rights, nothing of that nature. He just said it's denied pursuant to section 131.1C of the rules of the Chief Administrator. So let's take a look at 131.1C. It's on the state website, and here it is right here. Again, the section, audio, part 131, audio-visual coverage of judicial proceedings. Okay, so 131C, audio-visual coverage of party or witness testimony in any court proceeding other than a plea at an arraignment is prohibited. Well, we all know that is not true because we've all seen court cases on TV. You can ask Johnny Depp about that. So it says, let me see, audio-visual coverage of party or witness testimony in any court proceeding is prohibited. Well, that's just simply not true. But let's take a look at Section A. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, which was kind of the issue that we're having here, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings to the fullest extent permitted by the New York State Civil Rights Law. Mr. Ramseier didn't cite any New York State civil rights laws, but if he did, they support my position. And so does the First Amendment of the Constitution of the United States. And other statutes. And he didn't reference any other statutes or provide any examples whatsoever as to why it would be inappropriate. As interpreted by New York courts pursuant to the rules set forth below. So Section A is quite contradictory to Section C. And what I want you to understand is that these are rules of the chief administrative judge. These are not laws. These are policies. And policies do not trump the Constitution of the United States. State law does not trump the Constitution of the United States. So what I'm suggesting is Mr. Ramseier has violated my First Amendment right, freedom of the press. And I have the right to record in public spaces, so long as I'm not interfering with somebody else's rights. And as I've demonstrated here, I have violated nobody else's rights. There is no reason that this should be prohibited. The true explanation of why Mr. Ramseier doesn't want this thing recorded is self-serving. Let's take a look at Section B. Audiovisual coverage of proceedings in which the testimony of parties or witnesses by subpoena or other compulsory process is or may be taken is prohibited. So if somebody is being subpoenaed, against their will, they have rights, too. So that could be reasonable, and they could object to that, and then the judge theoretically determines whether or not their objection is reasonable. Right now, the judge in this case is just saying it's so because he said so, and he refuses to provide a logical explanation because there is none. Let's take a look at D. Nothing in these rules is intended to restrict any pre-existing right of the news media to appear at or report on judicial proceedings in accordance with law. Well, that's exactly what we're talking about here. Those rules are, in fact, restricting my pre-existing right, First Amendment right, of the news media to appear and to report judicial proceedings in accordance with law. So that's exactly what I'm doing. I'm disseminating these hearings for the public so they can see what goes on in assessment hearings. These should not be private meetings. The public needs to know. Let's see. Nothing in these rules is intended to restrict the power and discretion of the presiding trial judge to control the conduct of the judicial proceedings. Of course, the conduct in the proceedings needs to be kept civil, but the presiding judge cannot violate people's First Amendment rights in order to do so. Judicial proceeding, item F. No judicial proceeding shall be scheduled, delayed, reenacted, or continued at the request of or for the convenience of the news media. That's not relevant. We didn't ask that it be delayed for that purpose. We were ready to go in an unobtrusive manner. All I was going to do was put the video camera on the table, set it there, and hit record, and then we proceed. There's item G. In addition to their specific responsibilities provided in these rules, all presiding trial judges and all administrative judges shall take whatever steps are necessary to ensure the audiovisual coverage is conducted without disruption of court activities, without distracting from or interfering with the dignity or decorum of the courtrooms and court facilities, without compromise of the safety of persons having business before the court, and without adversely affecting the administration of justice. Again, all we're doing is setting a camera on the table, hit the button, and proceed. So this section does not apply in any way, shape, or form. There's absolutely no disruption as a result. If the assessor doesn't want to be recorded, that's too bad. It's her job to be recorded. It's a public position that she's in, and she needs to be accountable and transparent to the public. Same is true of the hearing officer. And the rest of us, my client and myself, want it to be recorded so that we can document what transpired. So that is my response to William Ramseier. It is so because he said so. He thinks that he can get away with that. And perhaps he can, but all I can suggest to you is that I don't think that behavior is the kind of person, has the integrity to be a state Supreme Court judge, and I do not endorse him for state Supreme Court judge. This is Mike Franklin, the property tax guy.